Hello, everyone, and welcome to Uncivil Law. And for today's stream, we are doing the certification of the Electoral College. It is January 6th. 4 years ago, we had a very exciting January 6th. Probably won't be as exciting today. Not for least of reasons, incidentally, that they changed the Electoral Count Act to make it less exciting. So under the old version of the Electoral Count Act, the one that they had had for like 150 years or so, it only took the objection of one member of the House and one member of the Senate to object to a slate. And then if they did object, then the houses would separate to discuss. And if they chose not to certify that state, then, they would do that. And we actually saw that process take place during the last certification. There was an objection to 2 or 3 states, I believe, as memory serves, not that that did any good. And then, of course, everything went to hell, as we all sort of remember from the frivolities of 4 years ago. But under the new exciting version of the Electoral Count Act, it now takes 20% of the House and 20% of the Senate to object, plus the grounds to object are much lesser. So probably not so much. So we probably will not see someone standing up be like, I've got this objection in hand, and I only, we used to see this, I only need the signature of one brave senator to bring this to the floor, blah, blah, blah. So now it's more, I need the signature of 20 brave senators to bring this to the floor. So probably will not see that. So it probably will be a much calmer, much more ministerial process than we've seen not only 4 years ago, but seen in the past, before that, with people who used to do that all the time. I have in my hand, that kind of shtick.
Mr. Speaker, the Vice President and the United States Senate.
They bring in the suitcases with the official votes. Very exciting. So those satchels have the votes in them. What is going on is we're trying to determine who the new president is going to be on January 20th. We're trying to determine who will be president. Could be anybody. The vice president is here in her capacity as president of the Senate. So we have the president of the Senate and the Speaker of the House in a joint session. So I imagine this is going to be pretty easy. They're just going to go state by state and say what the electoral votes were. And presumably, I don't even think there's going to be an objection. There's not even going to be an attempt at an objection. So they brought in extra seats for the senators to sit in. So those chairs are there for the senators to sit in, sitting in the well of the House. Grassley's there, looking old as dirt. Schumer, not looking quite as old. Incidentally, by the way, the United States Secret Service has declared this to be a special national security event. I'm not sure exactly what the exact nomenclature on that is, but it's the same designation they use for like the Super Bowl and also inauguration. It allows for the Secret Service then becomes the primary law enforcement agency in charge of coordination of security relating to this, and allows for more resources to be used. So the law enforcement aspect of this has been significantly elevated since last time. It was designated a national security event at the request of Congress. No, it might have been I know, well, it was the request of the mayor of DC. It might have, I'm not sure who else requested it, but it was designated a national security event. So law enforcement is at a peak. That obviously was not the case 4 years ago. So all right, guys, everyone take your seat. It's 1 o'clock. Let's go. Chop, chop, chop. It's 1 p.m. Let's go. Clock is ticking. Let's go. It's in the statute. This starts at 1 p.m. So they're breaking the law. Breaking the law. Who would be guilty of starting late? Technically, the Senate president. The Senate president outranks Speaker of the House. So technically, this is Kamala's fault that they're starting late. Thanks, Kamala. Can Trump reverse laws that they sign into effect? No, laws that are signed have to be, they'd have to be, a new law would have to be passed. Laws once signed become law. You can't just magically undo that. You need Congress to pass a different law. Yes, Kamala is late and gay. Yes. Yeah, she is starting the stream late. Claim the count has failed due to not starting on time. Nice. Can the speaker order people to take their seats? Sure. Kamala Harris would probably be preferring to certify her own election right now. I elect myself. I elect myself because I'm just the greatest. There's J.D. Vance.
And the House come to order. Mr. Speaker and members of Congress, pursuant to the Constitution and laws of the United States, the Senate and House of Representatives are meeting in joint session to verify the certificates and count the votes of the electors of the several states for President and Vice President of the United States. After ascertainment has been had that the certificates are authentic and correct in form, the tellers will count and make a list of the votes cast by the electors of the several states. The tellers on the part of the two houses will take their places at the clerk's desk.
Well, fortunately, we don't have to hear her voice for much longer. So, unless she becomes like governor of California or something, but then even then, hopefully, it'll be her voice will stay in California. Maybe she'll run for Senate. Maybe we'll have to hear her voice on the floor again at some point.
Action. Without objection, the tellers will dispense with reading formal portions of the certificates. After ascertaining that the certificates are regular in form and authentic, the tellers will announce the votes cast by the electors for each state, beginning with Alabama. Senator Fisher.
How about Canada? When do its votes get counted? We got some super secret votes from Canada.
The certificate of the electoral vote of the state of Alabama seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 9 votes for president, and J.D. Vance of the state of Ohio received 9 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Alaska seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 3 votes for president, and J.D. Vance of the state of Ohio received 3 votes for vice president.
So this could be very quick indeed if we carry on at this pace.
Madam President, the certificate of the electoral vote of the state of Arizona seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 11 votes for president, and J.D. Vance of the state of Ohio received 11 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Arkansas seems to be regular.
Yeah, this was
in form
televised
and
last time.
authentic, and
We
it
were
appears
streaming it
therefrom
last
that
time.
Donald J. Trump of the state of Florida received 6
Yeah,
votes for president.
it's televised.
And J.D. Vance of the state of Ohio received 6 votes for vice president.
Man, we'll be done inside a half hour. This will be a really short stream.
Madam President, the certificate of the electoral vote of the state of California
Could a state have separate
seems to
tickets
be
for president and
regular
vice
in
president?
form and authentic, and it appears therefrom that Kamala D. Harris of the state of
they
California
can vote for whoever they want for
received
president and vice
54
president.
votes for
I don't know if that answers your question.
And Tim Walz of the state of Minnesota received 54 votes for vice president.
The states can cast their electors for whoever they want for president and vice president. So,
Madam President,
but they can
the
only send one
certificate of
slate.
the electoral vote of the state of Colorado seems to be regular in form and authentic.
Why are they calling her Madam
It appears
President?
therefrom
'Cause she's
that
President of the
Kamala
Senate.
D.
That's the
Harris
correct
of the
title.
state of California received 10 votes for president,
Yeah.
and Tim Walz of
Madam
the state
President
of
is
Minnesota
correct title.
received 10 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Connecticut.
Yeah, it'll be
seems
the
to
only
be
time she's
regular
called that,
in
but
form
it is
and
correct
authentic,
title.
And it appears therefrom that Kamala D. Harris of the state of California received 7 votes for president, and Tim Walz of the state of Minnesota received 7 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Delaware seems to be regular in form and authentic, and it appears therefrom that Kamala D.
No,
Harris
she's
of
president of the Senate.
California
So,
received 3 votes
Madam
for
President is correct.
and Tim Walz of the
She's
state of
serving
Minnesota
in her capacity
received
as
3
president
votes
of the
for
Senate.
vice president.
That's why she's standing where she is. She's standing there because she's president of the Senate. So, Madam President is correct.
Madam President, the certificate of the electoral vote of the District of Columbia seems to be irregular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 3 votes for president, and Tim Walz of the state of Minnesota received 3 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Florida seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 30 votes for president, and J.D. Vance of the state of Ohio received 30 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Georgia seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 16 votes for president, and J.D. Vance of the state of Ohio received 16 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Hawaii seems to be regular in form and authentic.
wonder who
and it
Hawaii
appears
voted
from
for.
The Kamala D. Harris of the state of California received 4 votes for president, and Tim Walz of the state of Minnesota received 4 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Idaho seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 4
You got
votes
like the
for
like the
president,
little
and
formal
J.D.
seal you
Vance
can
of
kind
the
of see.
state of
It's got like that
Ohio
red wax
received
seal on it
4
and shit.
votes for
I'm
vice
a
president.
sucker for that kind of shit. You know, I'm a sucker for like the red wax seal and the ribbon and that kind of bullshit.
Madam President, the certificate of the electoral vote of the state of Illinois seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 19 votes for president, and Tim Walz of the state of Minnesota received 19 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Indiana seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 11 votes for president, and J.D. Vance of the state of Ohio received 11 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Iowa seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 6 votes for president, and J.D. Vance of the state of Ohio received 6 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Kansas seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 6 votes for president, and J.D. Vance of the state of Ohio received 6 votes for vice president.
Madam President, the certificate of the electoral vote of the Commonwealth of Kentucky seems to be regular in form and authentic, and appears therefrom that Donald J. Trump of the state of Florida received 8 votes for president, and J.D. Vance of the state of Ohio received 8 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Louisiana seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 8 votes for president, and J.D. Vance
Is
of the state
Louisiana
of
still a
Ohio
state?
received 8 votes for vice president.
We should double check that.
Madam President, the certificate of the electoral vote of the state of Maine seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 3 votes for president, and Donald J. Trump of the state of Florida received 1 vote for president, and Tim Walz of the state of Minnesota received 3 votes for vice president, and J.D. Vance of the state of Ohio received 1 vote for vice president.
See, that's one of the states that splits its votes, right? So cast 3 for one and 1 for the other. So that's an example of you can split your votes.
Madam President, the certificate of the electoral vote of the state of Maryland seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 10 votes for president, and Tim Walz of the state of Minnesota received 10 votes for vice president.
No, there were no disloyal electors in this election.
Madam President, the certificate of the electoral vote of the Commonwealth of Massachusetts seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 11 votes for president, and Tim Walz of the state of Minnesota received 11 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Michigan seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 15 votes for president, and J.D. Vance of the state of Ohio received 15 votes for vice president. Madam President, the certificate of the electoral vote of the state of Minnesota seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 10 votes for president, and Tim Walz of the state of Minnesota received 10 votes for vice president.
Madam President, The certificate of the electoral vote of the state of Mississippi seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 6 votes for president, and J.D. Vance of the state of Ohio received 6 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Missouri seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 10 votes for president, and J.D. Vance of the state of Ohio
It's
received 10
interesting
votes
that
for
Kamala
vice
Harris is using the House's gavel. The Senate's gavel is like a palm gavel. It doesn't
Madam
have a
President,
handle on
the
it.
certificate of the electoral vote of the state of Montana seems to be regular in form and authentic.
Kind of interesting, I
and it
guess.
appears therefrom that Donald J. Trump of the state of Florida received 4 votes for president, and J.D. Vance of the state of Ohio received 4 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Nebraska.
Also, I want to know where
seems to
I
be
get that
regular in
tray that they're
form and
using on the
authentic,
right-hand side, that
and it
silver
appears
tray.
therefrom that
Looks kinda cool.
Donald J. Trump of the state of Florida received 4
think I
votes
can get
for
that in the gift
president,
shop?
and Kamala D. Harris of the state of California received 1 vote for president, and J.D. Vance of the state of Ohio received 4 votes for vice president, and Tim Walz of the state of Minnesota received 1 vote for vice president. Madam President, the certificate of the electoral vote of the state of Nevada seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 6 votes for president, and J.D. Vance of the state of Ohio received 6 votes for vice president.
Madam President, the certificate of the electoral vote of the state of New Hampshire seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 4 votes for president, and Tim Walz of the state of Minnesota received 4 votes for vice president.
Madam President, the certificate of the electoral vote of the state of New Jersey seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 14 votes for president, and Tim Walz of the state of Minnesota received 14 votes for vice president.
Madam President, the certificate of the electoral vote of the state of New Mexico seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 5 votes for president, and Tim Walz of the state of Minnesota received 5 votes for vice president. Madam President, the certificate of the electoral vote of the state of New York seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 28 votes for president. Tim Walz of the state of Minnesota received 28 votes for vice president.
Madam President, the certificate of the electoral vote of the
Palm
state of North
gavels versus
Carolina
hand gavels. That's
seems
why
to be
we
regular
watch
in
you.
form and authentic, and it appears
Yeah.
therefrom that Donald J.
Thank you for
Trump
the
of the
super
state of
chat.
Florida received 16 votes for president, and J.D. Vance of the state of Ohio received 16 votes for vice president.
Madam President, the certificate of the electoral vote of the state of North Dakota seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 3 votes for president, and J.D. Vance of the state of Ohio received 3 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Ohio seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 17 votes for president, and J.D. Vance of the state of Ohio received 17 votes for vice president.
Did everyone send their thing using FedEx or UPS? Because it looks that way. It looks like all the states sent it
Madam
FedEx.
President, the certificate of the electoral
funny.
vote of the state of Oklahoma seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 7 votes for president, and J.D. Vance of the state of Ohio received 7 votes for vice president.
Yep, there's another FedEx package. Yeah.
Madam President, the certificate of the electoral vote of the state of Oregon seems to be regular in form and authentic.
When it absolutely
appears
positively
therefrom
has to be there.
that Kamala D. Harris of the state of California received 8 votes for president, and Tim Walz of the state of Minnesota received 8 votes for vice president.
Madam President, the certificate of the electoral vote of the Commonwealth of Pennsylvania seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 19 votes for president, and J.D. Vance of the state of Ohio received 19 votes for vice president.
If there were going to be drama, it would be per state.
Madam President, the certificate of the
So,
electoral
no
vote
drama
of the
today.
state of Rhode Island seems to be regular in
Is Rhode
form
Island
and
also
authentic,
still a state?
and it appears therefrom that Kamala D. Harris of the state of California received 4 votes for president, and Tim Walz of the state of Minnesota received 4 votes for vice president.
I've never been to Rhode Island. I'm not even sure I've ever passed through it, to be honest.
Madam President, the certificate of the electoral vote of the state of South Carolina seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 9 votes for president, and J.D. Vance of the state of Ohio received 9 votes for vice president.
Madam President, the certificate of the electoral vote of the state of South Dakota seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 3 votes for president, and J.D. Vance of the state of Ohio received 3 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Tennessee seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 11 votes for president, and J.D. Vance of the state of Ohio received 11 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Texas seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 40 votes for president, and J.D. Vance of the state of Ohio received 40 votes for vice president.
The Texas delegation says hi.
Madam President, the certificate of the electoral vote of the state of Utah seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 6 votes for president, and J.D. Vance from the state of Ohio received 6 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Vermont seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 3 votes for president, and Tim Walz of the state of Minnesota received 3 votes for vice president.
Madam President, the certificate of the electoral vote of the Commonwealth of Virginia seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 13 votes for president, and Tim Walz of the state of Minnesota received 13 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Washington seems to be regular in form and authentic, and it appears therefrom that Kamala D. Harris of the state of California received 12 votes for president, and Tim Walz of the state of Minnesota received 12 votes for vice president.
Madam President, the certificate of the electoral vote of the state of West Virginia seems to be regular in form and authentic, and it appears
Mountain
therefrom
Mamas, take
Donald
me home,
J.
baby.
Trump of the state of Florida received 4 votes for president, and J.D. Vance of the state of Ohio received 4 votes for vice president.
Madam President, the certificate of the electoral vote of the great state of Wisconsin seems to be regular in form and authentic, and it appears therefrom that Donald J. Trump of the state of Florida received 10 votes for president, and J.D. Vance of the state of Ohio received 10 votes for vice president.
Madam President, the certificate of the electoral vote of the state of Wyoming seems to be regular in form and authentic. And
Maybe
it
last in
appears
place,
therefrom
but
that
not
Donald
last
J.
in our
Trump of
hearts.
the state of Florida received 3 votes for president, and J.D. Vance of the state of Ohio received 3 votes for vice president.
Members of Congress, the certificates having been read, the tellers will ascertain and deliver the result to the President of the Senate.
We all know what the answer is. Well, that's okay.
The undersigned, Deb Fisher and Amy Klobuchar, tellers on the part of the Senate, and Brian Steele and Joseph Morelle, tellers on the part of the House of Representatives, report the following as the result of the ascertainment and counting of the electoral vote for President and Vice President of the United States for the term beginning on the 20th day of January, 2025.
The state of the vote for the President of the United States as delivered to the President of the Senate is as follows. The whole number of the electors appointed to vote for President of the United States is 538. Within that whole number, the majority is 270. The votes for President of the United States are as follows. Donald J. Trump of the state of Florida has received 312 votes. Kamala D. Harris.
Yeah, that's right. Suck it up. Suck it up.
Kamala D. Harris of the state of California has received 226 votes.
226 is a smaller number. I thought you needed 270. 226 is less than that.
The whole number of electors appointed to vote for Vice President of the United States is 538. Within that whole number, a majority is 270. The votes for Vice President of the United States are as follows. J.D. Vance of the state of Ohio has received 312 votes. Tim Walz of the state of Minnesota has received 226 votes. This announcement of the state of the vote by the President of the Senate shall be deemed a sufficient declaration of the persons elected President and Vice President of the United States, each for a term beginning on the 20th day of January 2025, and shall be entered together with the list of the votes on the journals of the House and the Senate. Thank you very much. Of the joint Senate having been concluded pursuant to Senate Concurrent Resolution Number 2, the 119th Congress, the chair declares this joint session dissolved. Thank you.
And that's it. That's all there is. It's clean, simple, to the point. No hysterics, no objections. We got it done in 30 minutes, baby. Clean. Done. Excellent. Very good. So, Donald Trump has been officially elected, and along with J.D. Vance, has been officially elected as president and vice president, respectively, for a term to begin on January the 20th at noon, as per the Constitution. Exciting. Grammar Tron 3000 says, I feel bad for Kamala's wine cabinet today. Yeah. This also may be the last time we hear from Kamala. This may be the last time we hear from her. I know it's very, very sad for us all, but we may never again hear that voice. I'm disappointed, but that's okay. When I'm feeling nostalgic, I can go back and listen to past recordings of Kamala and have that need satiated. So I'm good. So you. Did the Secret Service use a Pac-Man shaped perimeter this time? Well, actually, as we mentioned earlier, and you may have missed it at the top of the stream, the Secret Service has officially declared the counting of the votes on January 6th to be a national security event, whatever it's called. They have an official term for it. But it was declared to be a national security event in the same way that the inauguration or the Super Bowl is. So the Secret Service actually was the primary law enforcement agency in charge of security today, per statute. So the Secret Service may have had a Pac-Man perimeter. I'm not sure. But the security was, at a different level than in the past. They actually had security today. So, yeah, there was that. We can listen to past cackles. The cackles will live in my mind. The cackles may never leave my mind. The cackles are forever. So, I've got that to warm me at all times of the day and heart. So yeah, that's exciting. So we will be here, I imagine, for Inauguration Day. I'll be streaming Inauguration Day. I'll be streaming it as we watch this. And then, of course, also, by the way, as long as we're here to talk about something, we could try to pull up, since I have an audience. You know what I need? I need a copy of the motion that was filed by Donald Trump relating to stalling or to stay his sentencing. So I need a copy of that, and we could review that and discuss the law, because he was supposed to be sentenced on the 10th relating to the New York thing. But I think that he doesn't have to be, because I think he has a right of appeal before sentencing, because one of the issues is immunity. And when you have immunity issues, you can appeal immediately. So we could review that and discuss that as long as we're here. So let's see if we can find a copy, you and I together. So if you'll stay with me, we'll see if we can find a copy of it. But this might be a challenge. If my mods are listening to me, they're more than happy to help. Or for that matter, if any of you have a copy of it, you can give it to me on my Discord. That would be happy. That would be helpful. So we can search for it together. So hopefully one of us can find it before the silence gets us. Notice of, what's it called? Notice of stay. Okay. Found news articles about it, and then the interesting thing is trying to, okay, is this the one? Ha ha ha, I think I found it. That was easy. Ha 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 ha. I found it. Excellent. That was fast. Great. That wasn't so bad at all. Usually when I try to find things on the fly, it's a whole faff and it takes forever. So we're going to go and discuss this thing for a while. We turn our attention to the Supreme Court of the state of New York. Do not let the name deceive you, because when the state of New York says Supreme Court, what they mean is trial court, because the state of New York wants to confuse you. So where it says Supreme Court, just strike that completely out and write in trial court. Trial court. Because the state of New York likes to confuse you. Okay? We're in the trial court of the state of New York, in the county of New York, which is essentially Manhattan, in the people of New York against Donald Trump. President Trump's notice of automatic stay of criminal proceedings, or in the alternative, a motion for an immediate stay. Let's discuss the law. Will says, from my understanding, they're also supposed to give at least 10 days to prepare pre-sentencing reports. I don't know about that, so we'll see what the motion says, and we'll discuss the legal issues there too. President Donald Trump hereby provides notice to the court and the District Attorney of New York that he will initiate appellate proceedings on January 6, 2025, which is today, to challenge both this court's December 16, 2024 ruling, wrongly denying President Trump's post-trial presidential immunity motion, which arose from, among other established law and jurisprudence, President Trump's claim of presidential immunity, and this court's January 3rd, 2025 ruling, wrongly denying President Trump's motion to dismiss pursuant to law, which was based on, without limitation, a claim of sitting president immunity as extended interim transitional period. So as I sort of mentioned, there are certain circumstances in which you're allowed to appeal while a case is ongoing. We call it an interlocutory appeal, right? When you want to appeal while a case is ongoing, it's called an interlocutory appeal. And they are limited. They are very, very limited. There are very few circumstances in which you're allowed to do them. But one of those circumstances in which you are allowed to do them is if there would be no effective mechanism for redress if you didn't allow it. So sort of the classic example would be a defense based on double jeopardy immunity, right? I've been tried already for this crime, Your Honor, right? I've been tried and acquitted. And the state is bringing the case again. They brought it again. You can't do that. Now imagine the trial court says, no, you're wrong. You're wrong. You don't have double jeopardy immunity. But suppose the trial court's wrong, right? The trial court made a mistake. Well, if we didn't allow you to appeal right away, then there'd be no effective mechanism for review. Because if we only allowed you to appeal after the case was over, the very thing that you were immune from has already happened, right? The whole point was that you weren't supposed to be able to put twice in jeopardy. And now we've had a second trial. So the whole point was to prevent you from having a second trial. And now we've already done it. So we have to allow you to appeal immediately, because otherwise it would be too late, right? It would be too late for the relief to come. So immunity issues are globally a kind of thing that you are allowed to bring immediately. Double jeopardy immunity is a type of immunity, but not the only immunity. It could be an immunity based on a plea deal. It could be an immunity based on something else, right? It could be an absolute immunity because of your role. It could be whatever, right? So that's what he's saying. He's saying he wants to appeal the immunity decision. And he should be able to do that. And he should be able to do it immediately. And that should stay all the trial court proceedings, because that's how that normally would work. So that's what he's talking about. And that is a concept that is understood at law. So it makes sense to me. Okay. As discussed here in the commencement of appellate proceedings, which should result in the dismissal of this politically motivated prosecution that was flawed from the very beginning, centered around the wrongful actions and false claims of a disgraced, disbarred, serial liar former attorney, violated President Trump's due process rights and has no merit, seeking interlocutory review of these claims. And we discussed that above, right? Interlocutory review is what that's called. Interlocutory review of these claims results in an automatic stay of these proceedings under this court in case and related case laws conceded by past filings, which it really should. Due to the fact that further criminal proceedings are automatically stayed by operation of federal constitutional law, the court will lack authority to proceed with sentencing and therefore must immediately vacate the sentencing hearing for January the 10th and suspend all proceedings until the conclusion of President Trump's appeal on presidential immunity, which is correct. Until the appellate court has ruled, it should stay everything in the court below. That is correct. In the alternative, even if the filing of President Trump's appeal does not automatically stay these proceedings, which it does, the court should grant immediate stay of all pending proceedings, including sentencing scheduled for January 10th, pending the outcome of appellate review for the same reasons. Fair enough. All right, legal analysis. The U.S. Supreme Court's decision in Trump versus United States mandates a stay of further trial proceedings pending President Trump's immunity appeal. Before the United States Supreme Court decided Trump versus the United States, the only court to consider whether the filing of an appeal on presidential immunity mandates a stay of the underlying criminal proceedings pending appeal, the United States District Court for the District of Columbia, held the defendant's appeal on presidential immunity grounds automatically stays any further proceeding that would move this case towards trial or impose additional burdens on litigation defendant. Again, this is sort of how you would look at this from an immunity posture, right? As long as you have an immunity issue, this is what should happen. This is normal. This holding was correct, as the District Attorney of New York has effectively conceded. The U.S. Supreme Court's subsequent decision in Trump reaffirms that such a stay pending interlocutory review is mandatory and automatic, arising directly from the constitutional doctrine of presidential immunity. I don't really like this argument here because they say this is what the Supreme Court said, but please note there is no quote mark here, right? They don't say, okay, the Supreme Court said this, and then they say, here's a quote that says it, right? They just say this is the conclusion of U.S. versus Trump, which I'm not necessarily sure it is the conclusion of U.S. versus Trump so much it is the conclusion of how we deal with immunity issues in a more global sense. So I'm not necessarily sure that the U.S. Supreme Court said this in U.S. versus Trump, and one of the reasons I'm not sure they said it is because they didn't tell me they said it. They didn't give me a quote. But it doesn't really matter whether the U.S. Supreme Court said it or not, because in this particular case, because it is the state of the law, generally speaking. So that is how we handle that. All right. Trump mandates that President Trump may pursue, or the case Trump rather, mandates that President Trump may pursue an interlocutory appeal on presidential immunity supported by an automatic stay. In recognizing presidential immunity from a criminal prosecution for official acts, the Supreme Court has emphasized, and now thankfully they have a quote, thankfully, so that's helpful. The essence of immunity is its possessor's entitlement not to have to answer for his conduct in court. Because the president is immune from prosecution, a district court's denial of immunity is appealable before trial. And now finally they have some actual quotes that speak to this. So like this is much more on point, right? The district court, and here they're talking about a federal district court, but of course the logic would apply to a state trial court, right? Because the issue is the same, and this is an issue of federal law. So the Supreme Court wrote a district court, but because this is federal law, because of federal supremacy, because this is a federal issue, because the immunity is from the federal aspect, then this logic would apply to the state courts as well. So now we have a direct quote that's much more on point. Thank you very much. The Supreme Court has repeatedly emphasized the federal doctrine of separation of powers mandates interlocutory appeal of questions of presidential immunity must be available. The court interpreted Mitchell to stand for the proposition that questions of immunity are reviewable before trial because it's the essence of immunity is subject not to be suit. And that is exactly what we said when we talked about double jeopardy immunity, right? That is the whole thing. The essence of immunity is the entitlement not to be subject to the suit or the prosecution, as the case may be. That is the thing. Is this all tracking, by the way? I only ask because chat has sort of died. If you need me to like slow down or re-explain something or like clarify, I'm happy to, but I want to make sure that this is all tracking. Okay? And I'm explaining it adequately. Cool. All right. Yeah. The criminal process's extensive safeguards, though important, do not alienate the need for pretrial review. Good? Excellent. Because under a system of separated powers, criminal prosecutions cannot apply to presidential conduct to begin with. When the president acts pursuant to his exclusive presidential powers, Congress cannot, as an structural matter, regulate actions. So here we're going back to the decision in U.S. versus Trump. And here the Supreme Court is writing, when they're acting pursuant to exclusive constitutional powers, what the Supreme Court is talking about is the powers that are directly given to the president by the Constitution itself. The powers the Constitution just gives the president. For example, the power to pardon. And so if the Constitution gives the president the power, then Congress cannot regulate them because that would be an amendment to the Constitution, right? Congress can't pass a law that says the president doesn't really have the power because that would be an amendment. And courts cannot review them because, well, the president has the power and it's committed to the president. So the president has the power means no one else does. That's sort of in the nature of the thing. And so he does have certain exclusive powers that belong just to him, which is true, incidentally, for all the branches of government. You know, the House has the sole power to impeach. The Senate has the sole power to convict. The Supreme Court has the sole power to emphatically say what the law is. You know, that kind of thing. So the idea that one branch of government has power is not, that's even unchecked power is not a weird concept. There are certain circumstances in which one branch of government can act alone, and because the president is a branch of government unto himself, then, you know, well, he can do anything the executive can do because he is the executive. Accordingly, questions about whether the president may be held liable for particular actions consistent with separation of powers must be addressed at the outset of the proceeding, which includes interlocutory review. And this part is not in quote marks. That's just their conclusion, which is fine, but still noting. Even if the president were found ultimately not liable for certain official actions, the possibility of extended proceedings alone may render him unduly cautious in the discharge of his duty. Fair enough. Vulnerable to the burden of trial and inevitable dangers of outcome would dampen the ardor of all but the most resolute. The Constitution does not tolerate such impediments to the effective functioning of government, and thus the Constitution requires that appellate review of questions of presidential immunity proceed to completion before proceedings in the trial court. And again, here we're kind of treating this like other immunity issues. So the nature of the immunity may in some senses be special, but once you determine there's an immunity issue, the way we process it beyond that's not really special. So the way that we're treating once we determine that there's an immunity issue, we kind of treat it like all kinds of immunity issues. And this is how we treat all kinds of immunity issues. So that's fine. Celestial says, are there any underlying issues we should be worried about with the opposing party? None that come to mind, no. But thank you for your question. The Supreme Court's repeated citation of Mitchell versus Forsyth is particularly telling on this point. Like Trump itself, Mitchell mandates automatic say of trial proceedings when the immunity claim is on appeal and is widely cited for that proposition. And then they cite some claims that, say that. Mitchell held that denial of a substantive claim of absolute immunity is an order appealable before final judgment. So that's what you are looking for, right? That's interlocutory. Denial of the substantive claim of absolute immunity is an order appealable before final judgment, which is to say interlocutory. That's what that means while the case is ongoing. For the essence of immunity is the entitlement not to answer for the conduct. This requires a stay to protect officials from any burdens of litigation while the question of immunity is under review, including preventing the general costs of subjecting officials to the risk of trial and protecting those officials from even pre-trial discovery. Immunity, Mitchell held, is entitlement not to stand trial or face other burdens of litigation. This is an immunity from suit, and that part's really important there, so I'll highlight that. The entitlement is immunity from suit rather than mere defense of liability. So it's not just a defense, it's an immunity. It's more powerful than a defense, right? Because if it were just a defense, it might be like justification. Justification is a defense, like a self-defense case, right? Self-defense is typically a justification. It's a defense. It's an affirmative defense. So it's like, you murdered that guy. It's like, no, I didn't. I didn't murder him. I feared for my life. It was self-defense. My defense is justification. Well, that's a defense. I can have that defense at trial. It doesn't prevent the trial. It doesn't prevent the trial from happening. Now, some states, of course, have by statute created a situation where you can have a pre-trial hearing or other process. Looking at you, Florida, right? Looking at you, Florida, where you have some sort of process where you can have a pre-trial hearing to determine stand your ground, for example. But even then, you're still having the pre-trial hearing, right? Even then, you're still having the pre-trial hearing. So an immunity is even more powerful than that because it just like stops the entire thing completely cold. So it's not a defense. It's more powerful than that. Immunity entails an entitlement not to be forced to litigate the conduct. And again, you can compare self-defense, right? In a self-defense case, you're forced to litigate. You have the trial. But if there's an immunity, you don't have to litigate it. Now, you might have to litigate whether or not you have immunity, but that's not the merits of the thing, right? So litigating whether or not you have immunity is not the merits of the thing. We're not litigating, so you're immune from the merits while we figure out whether or not you have immunity or not. So that's what they're talking about. MJ Mean says, is there a legal way in New York for a plaintiff to charge a sitting judge with crimes? No, not really. No. Newspin says, could the restrictions on evidence in immunity ruling have some parallel to the Fifth Amendment protections? No. In terms of like whether or not the president's inner circle are immune or not, no. And the issues of whether or not those conversations are confidential has other law surrounding it. And you can cite Nixon for that proposition about the president's ability to confer with his most senior advisors. There's laws dealing with whether or not you can get evidence from those people or not. And Nixon is your best case on point there, relating there too. But your ability to get evidence from people is separate and apart from whether or not you can even charge them in the first place, right? So if you want to know if you can get evidence from Trump's senior advisors, I'd cite Nixon. If you want to know whether or not you can prosecute Trump, then I'd cite Trump versus United States. Okay. At a minimum, 3 features of U.S. Supreme Court opinion in Trump mandated on Max Day, all confirming the interlocutory appellate rights that Trump recognizes the case as part and parcel of presidential immunity, including an automatic stay of trial court proceedings in the interlocutory appeal relating to the court's rulings relating to official acts. As noted above, Trump held the essence of presidential immunity is its possessor's entitlement not to have to answer for conduct. Forcing a president to continue to defend a criminal case, potentially through trial, or even more dramatically here, through sentencing and judgment, while the appeal courts are still grappling with his claim of immunity, would force the president to answer for his conduct before the claim of immunity is finally adjudicated. And I mean, yeah, I mean, that's true, right? I mean, the sentencing is the final adjudication, so that isn't fair. It seems like the immunity issue should be resolved first. The Trump court references to the threat of trial, judgment, and imprisonment to make clear that presidential immunity violations cannot be ignored in favor of a rushed pre-inauguration sentencing based on a fatally flawed record that would lead to a wrongful judgment of conviction. Thus, denying a state appeal would do exactly what Trump repeatedly warned against. It would deprive immunity of its intended effect. It is of no moment, which is to say of no importance, that the court has suggested the intention to impose a sentence of unconditional discharge, because it's still a sentence. So even if the sentence is nothing, it's still a sentencing, right? What is indisputable that fabricated charges in this meritless case should never have been brought. At this point, could not possibly justify a sentence more onerous than that. No sentence at all is appropriate based on numerous legal errors, including legal errors directly relating to presidential immunity that President Trump will address in forthcoming appeals. The court's non-binding preview of its current thinking, which is true, fair enough. What the judges said they're thinking about doing is not binding on the court. The court can always change its mind. So the judge even saying, well, I'm not planning on throwing him in jail. That statement is not binding on the court. So they're correct. They're completely correct to note that. The court's non-binding preview of its current thinking regarding a hypothetical sentence does not mitigate these bedrock foundations. True. The Trump court repeatedly rejected the argument that it would have rendered presidential immunity ineffective in this fashion, holding that a mere allegation of unlawfulness cannot deprive the president of immunity. The Supreme Court reasoned that, if it were otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its effect. And that is sort of one of the big problems, right? It's like, even if you disagree with the U.S. Supreme Court case, the big meta problem is, well, if the president is not totally immune, if it's just like any time he violates the law, Lord have mercy. There's that book, 3 Felonies a Day, which argues the average person commits 3 felonies a day. And how many things the president is obligated to look after. It's like, how many things does he have to do in all kinds of fields? Can you figure out some way that you think the president's violating the law? If not, you're not trying very hard, right? It's like, it's actually really, really hard because the scope of his office is so vast, that if you put your maximum legal thinking hat on, you could probably find a law the president violates every single day. Because it's just, there's a lot of it. So if mere illegality was the benchmark, we would never get anywhere, because that's impossible. Likewise, regarding the government's demand to admit evidence of official acts of trial, which underlines on one of the president's key enumerations of error, the Supreme Court has held that the proposal threatens to eviscerate the immunity. The government's position is untenable in light of separation of powers. If official conduct for which the president is immune may be scrutinized to help secure his conviction, even on charges that purport to only be based on official conduct, the intended effect of immunity would be defeated. Given that presidential immunity entails immunity from the burdens of criminal litigation, such as trial and sentencing, forcing the president to defend a criminal case, especially at a sentencing hearing 10 days before he's due to become president again, while his claim is adjudicated on appeal, would eviscerate immunity by depriving immunity of its intended effect. The automatic stay pending appeal prevents this very injury. Second, as the United States Supreme Court has emphasized, the doctrine of presidential immunity nullifies the power of trial courts to act. Congress cannot act on, and the courts cannot examine, the president's actions on subjects within the conclusive and preclusive constitutional authority. Neither may the courts adjudicate a criminal prosecution that examines such actions. Indeed, pretrial review by interlocutory appeal is mandated, because under our system of separated powers, criminal prohibitions cannot apply to certain presidential conduct to begin with. When the president acts pursuant to his exclusive constitutional powers, Congress cannot, as structural matter, regulate such actions, and the courts cannot review them. This fact renders a stay pending appeal particularly necessary. The court should not continue to act while its very power to act is under appellate consideration. I mean, fair. The conclusion, moreover, is even more forceful when President Trump's claim of sitting presidential immunity, which all parties agree becomes comprehensive and absolute as soon as president takes office. Sitting president immunity extends into the brief transition period. I don't know about that, but we'll let them argue it. Sitting president immunity extends into the brief transition period during which the president-elect prepares to assume the executive power. I don't think so. That goes too far, but I appreciate your effort. This is exactly why the special counsel's office dismissed. Well, the special counsel office probably dismissed it because they didn't want to get whacked outside the backside of the head. So I'm not sure that was the reason the special counsel dismissed. They were probably dismissed because they wanted to, try to leave gracefully rather than having their ass kicked out. But whatever. During the transition period, the politically motivated charges brought in Florida and Washington against President Trump, and there's no basis for proceeding differently here by forcing a sentencing rather than allowing President Trump to pursue constitutionally mandated interlocutory appellate rights, which resulted in the mandated dismissal of the case. Third, the U.S. Supreme Court in Trump instructed that issues of presidential immunity should be resolved in a methodical, orderly fashion, not attempted at breakneck speed of the lower courts. The Supreme Court has chastised lower courts for proceeding without due care and caution. Despite the unprecedented nature of the case and very significant constitutional questions it raises, the lower court rendered their decisions on a highly expedited basis. I mean, they kind of did to some degree, to be honest. The underlying immunity questions raise multiple unprecedented and momentous questions about the power of the president and limits of authority under the Constitution. And even the Supreme Court was deciding the case on an expedited basis less than 5 months after it granted the government's request to expedite, allowing a criminal case to proceed to sentencing while federal appeal is pending about whether the case should be pending in New York County at all, and another appeal is pending directly challenging the court's presidential immunity rulings, would constitute highly expedited treatment at its worst. Indeed, this court's current schedule, denying President Trump's sitting immunity motion on January 3rd, and then scheduling a sentencing hearing just 7 days later, immediately before President Trump's inauguration, typifies the highly expedient treatment the U.S. Supreme Court cautioned against. For example, the rush timing in the current schedule forecloses the district attorney from New York from making a sentencing submission, which has to be served at least 10 days before sentencing, and violates President Trump's right to a full opportunity to his own. So, as mentioned earlier in chat, they are also violating the rules because the rush timing has prevented the district attorney from making their sentencing submission with enough time, and also violate President Trump's right to fully prepare his own sentencing memorandum as a violation of the law. So, it violates the CPL. So that's a big problem. It cannot be ignored that this rushed 7-day period between the ruling and sentencing has been imposed in cases that date back to 2018 and includes an enormous record of discovery and trial proceedings. In this context, there's no legal basis to rush ahead to sentencing rather than impose a stay, other than the District Attorney of New York's preference to get this done prior to inauguration and in advance of New York's, so that DA Bragg can tell voters in his upcoming election he completed the case. Likewise, in such appeals, whether litigation may go forward in the district court or trial court. Here I would have probably substituted stylistically. I probably would have substituted trial court for district court and put it in brackets. Rather than saying district court, I probably would have said trial court in brackets, but that's just me stylistically. It's precisely what the Court of Appeals must decide. The district court must stay its proceedings while the interlocutory appeal is ongoing. The logic applies with even greater force to an interlocutory appeal on far more momentous questions of presidential immunity from criminal prosecution. Thank you for chat. I appreciate you in chat for spending some time with me. It's very helpful. Indeed, the common practice of entering such stays reflects common sense. Absent automatic stay of district court proceedings, the U.S. Supreme Court's decision to afford a right to interlocutory appeal would largely be nullified. I mean, that's fair. What is the point of interlocutory appeal if proceedings are going to continue? it doesn't make much sense. If the district court could move forward with pretrial and trial proceedings, or worse, as here, criminal sentencing judgment while the appeal was ongoing, then many of the asserted benefits of presidential immunity would be irretrievably lost. Continuation of proceedings in the district court largely defeats the point of the appeal. Facts. A right of interlocutory appeal of the immunity issue without an automatic stay is therefore like a lock without a key, a bat without a ball, a computer without a keyboard. In other words, not especially sensible. The automatic stay of trial court proceedings required by Trump, Coinbase, and other jurisprudence extends to both claims of presidential immunity that President Trump is currently raising on appeal, presidential immunity based on evidentiary use of official acts, and absolute sitting presidential immunity from a criminal process extending to the president-elect. I'm not so sure about part 2 on that, but okay. First interlocutory appeal is inappropriate to the challenge of erroneously widespread admission of evidence of immune official acts, including, as here, the unlawful presentation of such evidence to both the grand jury and the trial jury. I don't know about the grand jury, but the trial jury, sure. As the case law is explained, immunity from evidentiary misuse of official acts is just as fundamental to the doctrine of presidential immunity as immunity from prosecution of official acts. If official conduct for which the president is immune may be scrutinized to help secure his conviction, even on charges that purport to be based only on unofficial conduct, the intended effect of immunity would be defeated. The district attorney's use of official acts evidence to probe presidential motive risks exposing even the most obvious instances of official conduct to judicial examination on mere allegations of improper purpose, thereby intruding on Article 2's interest that immunity seeks to present. Indeed, it would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of government if, in exercising that function, the president was under the apprehension that motives that control his office may at any time be subject to inquiry. The presidential immune conduct would be subject to examination by a jury on the basis of generally applicable laws. Use of evidence about such conduct, even where the indictment alleges only unofficial conduct, would thereby heighten the prospect that presidential official making would be distorted. Because evidentiary use immunity implicates the same constitutional concerns as direct prosecution immunity, it therefore follows that the stay should apply to the evidentiary use issues as well, which, fair enough as far as it goes, because whether or not that evidence could be offered or used is still very much an issue that needs to be resolved. Second, President Trump's claim of sitting president immunity implicates all the same policies and concerns as official act immunity and heightens the need for automatic stay. All parties agree that once President Trump assumes office, he'll be absolutely immune from any criminal process, state or federal, under the doctrine of sitting presidential immunity. But this court's decision to schedule a sentencing hearing on January 10th, 2025 at the apex of the presidential transition, we don't know about that, but whatever, and 10 days before President Trump assumes office, necessitates that President Trump will be forced to continue to defend his criminal case while he's in office, at the very least on appeal from judgment. That's fair too. Like, it would force him to continue his case while he's in office on appeal. That's a fair point. Moreover, the district attorney could also pursue an appeal of any sentencing determination they view as contrary to law. Thus, under the current schedule, instead of facing no further criminal proceedings while he's president, President Trump will be forced to deal with criminal proceedings for years to come, which is the opposite of what the doctrine of sitting president immunity requires. Forcing President Trump to prosecute or even defend a criminal appeal during the term of his office, an appeal that could result in remand for another criminal trial during President Trump's term, is itself a clear-cut violation of sitting president immunity. Moreover, the prospect of imposing a sentence on President Trump just before he assumes office as the 47th president, and I cannot wait, I hope you and I are on accord on that one together. I cannot wait for that to happen. It's going to happen soon, though. 14 days, baby. Holla. 2 weeks. 2 weeks, baby. Raises the specter of other possible restrictions on liberty, such as travel, reporting requirements, registration, prohibitionary requirements, and others, all of which would be constitutionally intolerable under the doctrine of sitting presidential immunity. These constitutional errors would compound the already grave constitutional problems with this proceeding raised in our prior proceedings, including forcing the jury in record time without proper process. You're Canadian, You've got your own problems, so I understand. You got your own problems, so I understand. Because the right of interlocutory appeal and automatic stay prevent a trial court from proceeding to trial pending immunity, it also follows a fortiori. The same rights prevent the trial court from forcing President Trump to undergo criminal sentencing and judgment while immunity appeal is pending. As the Trump decision repeatedly emphasized, presidential immunity protects the president from the entire suit, not just certain stages of the suit. The essence of immunity is the possessor's entitlement not to have to answer for his court and conduct. Official immunity, including Presidential Official Act immunity, is immunity from suit rather than mere defense of liability. And I will highlight that again because that is a big deal. Immunity from suit rather than mere defense to liability. That is a big, big deal. Thus, President Trump's immunity from suit extends to immunity from the imposition of criminal sentence and final judgment as well as trial, because the framers designed the presidency did not envision such counterproductive burdens on vigor and energy of the executive. Thus, President Trump must be afforded the opportunity to litigate his claims on appeal before the proceedings can move ahead to the merits, including before any merit-related discovery. Whereas here, moving ahead to final judgment on the merits. Indeed, undergoing a criminal sentencing is the most extreme answer of having to answer for conduct in court, exactly what the doctrine of presidential immunity forbids. To be clear, the filing of President Trump's appeal on immunity automatically stays further criminal proceedings in this court, including the imminent sentencing hearing scheduled for January 10th, 2025, pending the outcome of an appeal, and does so as a matter of federal constitutional law. As the U.S. Supreme Court Trump decision makes clear, this automatic stay is an essential part of the federal doctrine of presidential immunity itself, which arises from the very structure of the United States Constitution. As a matter of federal constitutional law, the doctrines of presidential immunity binds the New York court under the Supremacy Clause. That is pretty important, right? The doctrine of presidential immunity binds New York courts under the Supremacy Clause. See Trump v. Vance. Lol. Lol. Different Vance. When judicial authority is invoked in aid of the United States authority and federal and field of powers, state constitutions, state laws, and state policies are irrelevant to inquiry and decision. It is inconceivable that any of them can be interposed as an obstacle to the effective operation of federal power. Vitally, there's no conflict between the Supreme Court's automatic stay doctrine and Trump and New York appellate law in practice here, because President Trump is equally entitled to a stay under New York law. The relevant law explicitly authorizes a stay on further proceedings in a trial court pending resolution of an Article 78 proceeding. Relying on this provision, New York appellate courts routinely grant stays of criminal proceedings, while a trial court's authority to conduct further proceedings is subject to appellate review in an Article 78 proceeding. Such stays of criminal proceedings include cases granting a stay to prevent a trial court from conducting a sentencing hearing pending decision on the Article 78 petition to block the sentencing from occurring, which is the exact posture of this case. They also include stays issued at the prosecution request, not just the defense. The relevant law's authorization of stays in all further proceedings in criminal cases in New York courts, common practice of granting such stays, implement the same policy reflected in the Supreme Court's decision in Trump. In fact, it would be astonishing if such a stay, which is routinely granted in garden variety cases, were denied to the President of the United States claims of immunity. By virtue of the President filing an appellate claim, raising claims of immunity, all proceedings in this court are automatically stayed by operation of federal law. In the alternative, even if it were discretionary, the court should grant a stay. The court should vacate the sentencing hearing scheduled for January 10th and suspend all further deadlines in this case until President Trump's immunity appeals are fully and finally resolved, which should result in the dismissal of this case, which should have never been brought in the first place. Further, President Trump respectfully requests that this court notify the parties by Monday, January 6th, to 2 p.m., where this court intends to proceed with sentencing hearing on January 10th, which should not occur notwithstanding the interlocutory appeal. So I'm not sure whether or not the court met that deadline, but that all seems legally correct to me. So I think that all sounds right. Again, you can quibble with the U.S. Supreme Court's decision on immunity. You could disagree with parts of it for sure, but it is the state of the law at the moment, and immunity issues like this are typically resolved on an interlocutory appeal. So I think that all makes perfect logic sense. So that's pretty much all there is to say about that. So I don't know if there's any questions, but if not, I'll pretty much wrap things up. I appreciate you spending some time with me. It's I couldn't care less. You're correct. It is I couldn't care less. Did I misspeak? I might have misspoke, but you're correct. It is I couldn't care less. All right, let's see. Where shall I send you? I'll send you to Robert Guvera. He's a nice guy. He's doing some stuff that's relating to Trump and stuff, so I'll send you his way. Tell Robert I said hi and I love him, and maybe we can collab sometime in the near future. Until later, my friends, I've been Uncivil Law. I hope all is well. Till later, my friends.